Hello everyone, welcome back to our session on liquidation under IBC. So in the previous session, we were discussing the process of liquidation. We have seen what triggers a liquidation process, and then we have seen how the liquidator plays a role and what are his powers, and we have seen what constitutes part of a liquidation estate and what are the exclusions for it. Now let us dive into the process part of the liquidation process. Liquidation. So, upon appointment of a liquidator, as we have already discussed in the previous session, a liquidator is required to issue a public announcement under Form B. So, this public announcement invites claims from various creditors, and it has to be published on the website of the corporate data, the website of IBBI, and it shall be published in the newspapers, one in English and in the vernacular language of the registered office. So we have discussed this at length in the previous session, so I'm not going to elaborate on this here. Once the claims are called for and received, the liquidator then forms a liquidation estate. So liquidation estate, as we have discussed, contains all of the assets of the corporate debtor. All of the assets that may be liquidated are included in the liquidation estate. Now, we have seen certain exclusions in the previous session. Basically, any property belonging to either the guarantors or the directors of the company will not be included. There is another category of assets that will be excluded from the liquidation estate. Assets called onerous property. So, any assets which are not readily saleable, and if the liquidator is unable to realize any amounts, he may file an application before the adjudicating authority stating that such a property is an onerous property. It could be a physical property or it could be any contract which is unprofitable to the corporate debtor, and disclaim such an asset. Once such disclaimer is made, then that particular asset will no longer be considered as part of the liquidation estate. If there is any asset that is burdened heavily by litigation and there is a questionable title subject to other factors, the liquidator may file an application before the adjudicating authority stating that such an asset is an onerous property and that he wishes to disclaim it. So, any party that is affected by such disclaimer shall also file a claim. If such claim is subject to verification, the liquidator may accept the claim. So, after after the formation of the liquidation estate comes verification of claims. Verification of claims is a very similar process as that under the CIRP process provided in the CIRP regulations, as we've discussed in the CIRP portion of the lecture. So, the liquidator here, as I've mentioned, poses an adjudicating role in the verification of claims. So, it means that he is empowered to call for such evidences for substantiation of the claims. So the liquidator may require any such documents that will support the claim of any stakeholder, and he can go a step further and take the support of any of the governmental agencies or departments to understand and verify the claims. The adjudicating authority plays the role of an appellate authority here. The NCLT acts as an appellate authority from the decision of the liquidator. If an aggrieved party by the party aggrieved by the liquidator's decision may approach the NCLT for its redressal, grievance redressal, essentially. So, once the verification of claims is done, the liquidator will file a list of stakeholders with the adjudicating authority. Once such a list of stakeholders is filed, a committee is constituted, stakeholder consultation committee. So this committee, as we've seen, includes all of the stakeholders involved in the corporate liquidation process. So all the stakeholders will be given a voting right in proportion to the debt owed to them against that of the total debt of the corporate debtor. So similar to that of a COC, any major decision will be taken with a 66% voting right, and any decision such as replacement of the liquidator, approval of the mode of sale, and appointment of certain professionals, and say approving the liquidation costs, and taking any such decisions that will enable the liquidator to continue the corporate debtor as a going concern. As we have discussed in the previous session, in every meeting of the stakeholder consultation committee, the liquidator takes chair of the meeting and he circulates the agenda prior to the meeting, and also he presents the actual liquidation costs, the progress made in terms of the liquidation process, and any progress in material litigation related to the corporate debtor. All of such details are provided in every single meeting. Once such meeting is concluded, minutes are written down and circulated to all of the stakeholders. And as you already know, no related party will have a vote in a stakeholder committee. So once the verification is also concluded, the liquidator then submits the first progress report. So essentially, the liquidator is required to submit progress reports at different instances. The first report is submitted, the preliminary report is submitted, any progress report is submitted 15 days after the quarter ends. So the first one would be 15 days after whichever quarter the liquidator has been appointed. If supposing the liquidator has been appointed on 1st of March, and since the quarter ends at 31st, he may submit his report before on or before 15th of April. 15 days is given after the quarter, whatever quarter that he has been appointed in. So such progress reports are to be submitted after every quarter. So what does this progress report contain? The progress report is required to convey all the uh, details of the liquidation process, the progress that has been made, the litigation updates, and such other things that are discussed and decided in the meeting of the stakeholder committee. And if the liquidator, as I have told you, the liquidator is not bound by the suggestions of the stakeholder consultation committee. It is merely a suggestion, and that the liquidator is empowered to take decisions in the best interest of the corporate debtor by himself. However, if it is contrary to the decision of the consultation committee, stakeholder consultation committee, then he is required to submit reasons in a written format to all of the stakeholders. So all of these things and the progress made in terms of the distributions and realizations will also be included in the progress report and submitted to the adjudicating authority. So the liquidator is also required to submit to create an asset memorandum. Like we have seen in the CIRP process, there is an information memorandum. An information memorandum essentially is given to the resolution applicants and the CEO, members of the COC. It contains all the details of the corporate debtor. It is required to have the profile of the corporate debtor, the financial details and the status in previous years' financial statements that have been the previous year's audited financial statements, and the history of litigation, any pending litigation, whatever there is, and the list of material assets of the corporate debtor, shareholding patterns, and then it can also have the uh, any such other information that is required to be provided. So an asset memorandum is similar to an information memorandum, wherein all of the assets of the corporate debtor are listed out, all of the financial details are provided, and also the status of any material litigation is also provided here. So before issuance of this asset memorandum, even to the stakeholder committee, the liquidator may share it only after having received the confidentiality agreement. So he issues a confidentiality agreement to all of the stakeholders, and he may share the asset memorandum only after having received the confidentiality agreement. Just like in the case of an information memorandum, wherein the committee of creditors and the resolution applicants, whoever are entitled to receive the information memorandum, shall also share the confidentiality agreement. Since such asset lists and such data would be confidential to the corporate debtor, and it may be detrimental if uh, a, if a third party who is not related to the proceedings is made privy to such information. The parties who are made aware of such confidential information also are required to state that they will also protect the copyright of the corporate debtor. Now, let us understand asset valuation. So, under liquidation, the members of the stakeholder consultation committee may either choose to continue using the valuation report that was provided by the provided by the registered valuers during the CIRP process, or if there has been a substantial amount of time that has lapsed and the stakeholder committee considers that such a gap might have caused a serious change in the valuation of the assets, they may decide to have registered valuers appointed even in a liquidation. So ordinarily, if you look at the processes under DRT, any valuation report, if it is older than 6 months, then a fresh valuation report is required. Similarly, here the discretion is upon the stakeholder committee. If the industry is such that nothing would happen to the assets of the corporate debtor even after 6 months and that they're not perishable or anything. If in case there is perishable goods, then that's a different ball game altogether. But if say suppose it's like a steel industry or something along those lines, and the shelf life uh, like that of a perishable good does not apply to industries like this, then they may also opt to continue using the same valuation reports. However, if they choose to appoint new valuers, again, even under liquidation, two sets of valuers for all the three asset classes must be appointed. Registered valuers for a valuation of plant and machinery, land and building, securities and financial assets. Two registered valuers for each class of asset must be appointed. And the valuation given by both the registered valuers, the average of both the valuers will be taken as the valuation. So the registered valuers provide two types of valuation. They provide fair value and they provide liquidation value. So fair value would have been something that the corporate debtor will be able to realize under ideal circumstances, and that would be the value of the asset. Liquidation value is the minimum amount that they may realize out of the asset. So under liquidation, if the registered valuers, if both the registered valuers, there is a significant difference in the values given by the valuers, then a third valuer may be appointed. Just like in CIRP, a third valuer may be appointed for whichever class. If the discrepancy is only for one particular class, then a valuer only for that particular class of asset may be appointed, and the valuation given by the third valuer will be compared as against the first and the second valuer. Whichever valuation the third valuation comes close to will be taken, and that will, those two values, the average of those two values will be considered as the valuation for the entity. So these valuation is also to be provided to the stakeholder consultation committee, and this is also included in the asset memorandum. So basing on this valuation, is where the stakeholder consultation committee is how they will decide what mode of asset sale is to be opted for. So there are multiple types of asset sales. Asset sale can happen either as a parcel, either in a slump sale, as a going concern, or as a unit, or as a individual asset. So the mode in which the liquidation and the asset sales are required to happen is the discretion of the stakeholder committee. And to facilitate them in taking such a decision regarding the asset sale, the liquidator is going to provide them with all of such information. Whichever, so the liquidator will provide them that such and such amount is the liquidation value, and uh, this a specific timeline that will also be provided to the stakeholder committee, stating that the asset is expected to be sold within such a timeline. This is the expected value if it is sold within this timeline, and this is the actual realized value after the sale and the distribution thereof. So the liquidator acts as a he basically facilitates the stakeholder committee to arrive at a decision in order to maximize their realization of from the assets. So an auction can take place in multiple ways. Auction of so there are multiple various platforms provided by either, so the information utility is run by NESL. So NESL also provides an auction platform where the liquidator may provide the details of the asset and have the auction process virtually, facilitating a quicker sale process. So once the sale is made and the amounts are realized, the liquidator is required to distribute such amounts within 90 days. So we will understand in what manner the distribution is made in the subsequent slide. And once the distribution is made, then the company is dissolved after submitting an application to the NCLT. So let us get to the waterfall mechanism. So under the waterfall mechanism as provided under, so the distribution, order of distribution and priority is provided under section 53 of the Insolvency and Bankruptcy Code, which is also called as the waterfall mechanism. So in this, effectively you understand why it is called a waterfall mechanism, right? So starting with the insolvency costs and liquidation expenses. Initially, whatever costs that were incurred by the IRP and by the RP subsequently, and liquidator ultimately, all of these costs put together will have to be paid. Any dues towards insolvency costs, any dues towards liquidation costs will have to be paid first. So once that is done, then secured creditors and workmen's due. So these creditors will be considered pari passu. So regarding the insolvency and liquidation expenses, if in case the liquidation value of the entity is lower than the liquidation expenses or the insolvency expenses or the projected liquidation expenses itself, then the liquidator may propose to the stakeholder committee for an early dissolution of the company. He may essentially inform the stakeholder committee that such a liquidation is not viable, as not even the liquidation and insolvency costs will be covered, leaving aside the rest of the stakeholders. Nobody is going to realize anything. So then a premature dissolution of the corporate debtor may be proposed, and such an application can be filed by the liquidator before the NCLT or adjudicating authority. So coming to secured creditors and workmen due. So secured creditors and workmen, they are the dues towards both of these are considered pari passu, which means on an equal footing. So any secured creditor and a workman whose dues are in the preceding 24 months will be considered pari passu. So we have understood who can be secured creditors in the CIRP part of our lecture. Even statutory and government dues, though are explicitly provided in the subsequent portions of the waterfall mechanism, if they create a charge, then even though they are government dues, they may also be considered as secured creditors. This was the finding of the Supreme Court in the case of Rainbow Papers. So, as we have seen, for a secured creditor to come under the waterfall mechanism in this second place, they have to have relinquished their security interest into the liquidation estate under section 36 of the code. However, if the secured creditor has not chosen to relinquish the their security interest, then they will fall in the lower strata of the waterfall mechanism. Then, after secured creditors comes other workmen's due and unsecured creditors. Other workmen's due preceding 12 months and unsecured creditors. Here, again, both of these stand on equal footing and are pari passu. Government dues and remaining secured creditors. So the government dues, whichever dues that do not create a charge, and the any dues towards central, state and local authorities and departments of the government will fall under this category. Any statutory dues essentially. And remaining secured creditors. So remaining secured creditors are the ones who have not relinquished their security interest into the liquidation estate, but after having their security interest realized under section 52, have an amount yet to be realized. If their full debt amount is not realized under section 52, then they may come under this strata in the waterfall mechanism. So secured creditors, if they choose not to relinquish their security interest into the liquidation estate, they may inform the liquidator about their decision. So once such information is provided to the liquidator will then have to look for a buyer for that particular asset. Once the security is identified, the secured creditor is also required to provide that such and such an amount is expected to be realized from that particular asset. See, supposing there is a land that is worth 10 crores, then the secured creditor will state that this is the amount that we are expecting you to realize from this particular asset, and they will instruct the liquidator that he may find a buyer for such an amount. If the liquidator finds a buyer for that amount or a higher amount, then he will sell it to that particular buyer. And if their debt is, supposing if the debt owed towards such a secured creditor is lower than the security than the amount realized from the security interest, supposing the debt is around 8 crores and the actual realized value is 10 crores, then the remaining amount will be considered to have been relinquished into the liquidation estate. And if the actual debt amount is 12 crores and the realized value is only 10 crores, then the secured creditor will again come in the line under waterfall mechanism. So if the liquidator fails to find a buyer for the amount as required and fails to find a buyer essentially for that asset, then the secured creditor may also attempt at finding a buyer. If the liquidator has found a buyer, then the secured creditor will have to bear the expenses of having identified a buyer by the liquidator. However, if the liquidator has not found one and the secured creditor has found a buyer, then such expenses incurred by the secured creditor will have to be borne by the liquidator. And the secured creditor will also have to realize an amount not less than the amount that was provided to the as stated to the liquidator. So they cannot go below the 10 crore limit that they have set to the liquidator. They will also have to sell it at the same rate. If they fail to sell, even if the secured creditor also subsequently fails to sell, then that asset will come under the liquidation estate again. It will be considered relinquished into the liquidation estate. So that secured creditor who has not managed to realize any such values will be considered as a secured creditor and will stand second in line, not as remaining secured creditors. Now, after government dues and remaining secured creditors comes operational creditors and other unpaid dues. So, operational creditors, any other operational creditors than statutory authorities and workmen. So it can include basically vendors and such other operational creditors will fall under this category. And any other unpaid dues, any other basically other creditors fall under this category. So here, secured creditors and workmen's due and government dues and remaining secured creditors fall in pari passu basis, and the rest falls in the order that it is mentioned in. Once all the other creditors are also paid off, then if any amounts are still left, preferential shareholders, if there are any in the company, and then subsequently equity shareholders, if anything else remains. Generally, what is observed is that in no liquidation, I'm making a very generalized statement. It is not 100% rule. However, commonly, beyond the secured creditors, none of the other stakeholders have been realizing any amounts. Operational creditors are provided with bare minimum nominal amounts. They might have any scope for recovery either in CIRP, or if the corporate debtor, even under liquidation, is being sold off as a going concern. So if a company is being sold as a going concern, then the new management that is going to come into the picture will also have to ideally have a good functioning relation with the operational creditors and the vendors. So the salary creditors are very important for the going concern. Hence, in those circumstances, will the operational creditors see any money? So even under the liquidation process, liquidator may sell such assets only to those only to such people who are eligible to be resolution applicants. They need to meet with all the criteria stipulated under Section 29E. Now, after having seen the waterfall mechanism, after the conclusion of distribution under the waterfall mechanism, the liquidator periodically he has already been submitting progress report. However, after conclusion of all the distributions, then he will have to make a detailed report, a final report to the adjudicating authority. So this report will state the amounts realized and that all of the assets have been realized, and the liquidator, as I've told you in the previous session, is empowered to initiate any litigation as well for the in the interest of the corporate debtor. Essentially, since the company is going to be wound up, they he will also initiate proceedings against sundry debtors. The corporate debtor may also have other debtors, and any amounts that are due towards the corporate debtor will the liquidator will attempt to realize such amounts. Even a resolution professional is also empowered to do so. In fact, when a public announcement is made, it is a common practice that a resolution professional or an IRP or a liquidator will send out intimation letters to various statutory authorities, to financial institutions seeking their claims, and similarly, after having looked at the books of accounts of the corporate debtor, they will identify any debts that are owed to the corporate debtor and any debts that are owed from the corporate debtor, and send intimation letters regarding either the CIRP or the liquidation of the corporate debtor, and seek that such creditors or debtors take necessary action. So the amounts are called from such debtors also, and whatever amounts that are realized from such debtors will also form part of the liquidation estate, and those amounts will be distributed in accordance to this. So if any amount is realized, then it will have to be paid in this particular order. Say supposing let's assume that insolvency costs and liquidation costs have already been paid off. Now coming to secured creditors and workmen's due. So if an amount of 10 crores is realized after having sold off assets, and the actual debt amount, uh, since secured creditors and workmen's due fall on pari passu basis, they are on this equal footing, such 10 crores will have to be distributed proportionately amongst such creditors. If the secured creditors owe a total debt of 80% while worksman due is for 20%, then it will be distributed proportionately. Supposing the secured creditors and the workman due totals an amount of say suppose 6 crores, then the remaining amount will be used to proportionately distribute amongst in the waterfall mechanism. The other workmen dues, employees dues for preceding 12 months, then the unsecured creditors, they will also have to be paid in that order. If there are any remaining amounts after having distributed to all of the stakeholders in the waterfall mechanism, the board maintains a liquidation account with a public sector bank, a scheduled bank, and such amounts are to be deposited over there. Any unpaid dividends and such other amounts will be paid in that will be deposited in that amount account maintained by the board. So now let us look at avoidance transactions. So we have seen in CIRP also, in liquidation also, that the liquidator or the IRP or the RP is required to initiate applications for avoidance transactions. So let us understand what these avoidance transactions are. Section 43 provides for preferential transactions. What does preferential transaction mean? It means favoring specific creditors in such order against that of what is provided in section 53. So the order of priority will not have been, if it is not followed and a specific creditor is given a preference while repaying a debt or having such a transaction with a creditor, which in turn results in such a consequence where a stakeholder is being given precedence over the rest of the stakeholders, that is considered as a preferential transaction. So under preferential transaction, any transaction of this nature having taken place 1 year preceding the insolvency commencement date in case of any party, and 2 years preceding the insolvency commencement date will be called as a preferential transaction. And such a preferential transaction will have to be, if upon identifying it, the resolution professional will file an application before the NCLT. So once the application is filed, the court essentially returns the position of the corporate debtor prior to having made such a preference. So basically it restores the order as prescribed by the court. So the IRP or the RP may appoint a transaction auditor. A transaction auditor will look into the accounts of the corporate debtor and identify if there are any avoidance transactions. The insolvency professional, in whatever capacity, may seek assistance and aid from such transaction auditors. So these transaction auditors are licensed specialists who will look into the books of accounts of the corporate debtor. Now, Section 45 provides for undervalued transactions. Basically, if any assets of the corporate debtor are sold at a throwaway price, at a price so low that it is unrealistic. It may be given off as a gift, or it may be sold off as at a nominal price outside the course of its ordinary business. Same is in case of preferential transactions as well. Such a transaction should have taken place outside its ordinary course of business. And the party who is receiving such a benefit should not have, if they have done so in good faith, then such transaction may not be considered as a avoidance transaction. So in undervalued transactions, again, the look back period, or the period during which the transaction is identified to have happened, is the same as in the preferential transaction. 1 year for any other party, 2 years for related parties. And if such assets are being sold with a fraudulent intent to defraud creditors of the corporate debtor, it falls under the purview of Section 49, which states that sale of assets at an undervalued rate to defraud the creditors. That will also, an application to that effect will have to be filed by the liquidator or the resolution professional. So then, coming to fraudulent transactions. Fraudulent transactions, as provided under Section 66, is a generic clause. It is intentional misconduct leading to failure, or intentionally taking such action which will result in defrauding the stakeholders of the corporate debtor. So fraud, as we have seen under Contract Act, is void ab initio. So there is no look back period for fraudulent transactions. If it is a fraud in 2008, if it is a fraud in 2018, it is still fraud, and such a transaction will be considered void, and the adjudicating authority will try to restore the position of the corporate debtor prior to such a transaction having taken place with regards to that particular asset. So under undervalued transaction and a preferential transaction, the adjudicating authority may restore the position of the corporate debtor by either reversing the transaction or by restoring the interest of the corporate debtor in that particular asset, in interest or possession in that particular asset. And such an action may be taken in the fraudulent transactions as well. And coming to extortionate credit transactions. Extortionate credit transactions under Section 50 provides that any terms of credit given to the corporate debtor which have exorbitant rates of interest or unreasonable terms of credit will be considered an extortionate credit transaction. Any term which is not necessarily ordinary and which imposes an extreme stress or puts a corporate debtor in such a position will be considered as an extraordinary credit transaction. And upon filing an application to the adjudicating authority may either reverse the credit transaction or may remove the problematic clause or take such other necessary decisions. So, a resolution professional or a liquidator is required to necessarily, upon identifying such transactions, file an application before the adjudicating authority. So they are empowered to take all such data available either with the corporate debtor and take assistance from other professionals to identify these transactions, and after having identified these transactions they are required to file an application before the NCLT. However, if after having all the possibility of after having all the possible chances and after being able to access all such information, a liquidator or resolution professional still fails to identify any of these transactions, even though they are present in the corporate debtor, then the creditors of the corporate debtor may identify such transactions and make an application to the adjudicating authority. So once such creditors make an application to the adjudicating authority, the adjudicating authority will on merits decide the avoidance transactions, and they will issue directions to the Insolvency and Bankruptcy Board to initiate disciplinary proceedings against the resolution professional or the liquidator as well. So once such transactions once an application for such transactions is filed by the liquidator or the resolution professional, the treatment in which it is handled after the realizations, if any, come out of such transactions. Avoidance transactions are also called as PUFE transactions, PUFE. So, any of these transactions, once the realizations arrive, in CIIP, a resolution plan is required to address this aspect as to whether the creditors, committee of creditors, or if the previous other stakeholders of the corporate debtor will be realizing the amounts, or if the resolution applicant will be realizing the amounts. This is a highly debated topic, and the manner in which the transactions will be uh, litigated is also decided based on who is going to realize naturally. If the committee of creditors are going to realize the amounts, then they would want a representative of theirs who can also be the resolution professional pursue the PUFE transactions on their behalf in the NCLT, because these transactions may take time and they are adjudicated separately. After the resolution plan is approved, PUFE applications may still be pending. So someone needs to pursue such an application, and they may appoint someone for that, either the resolution applicant or the committee of creditors, which however way they negotiate. And in a similar manner, in liquidation, what the manner in which such realizations are to be dealt with has to be decided by the stakeholder committee. The Supreme Court, in the case of Ghanshyam Mishra, has in depth discussed the manner in which PUFE transactions they are to be treated and identified. So once all of this is concluded, then a dissolution application is to be filed before the NCLT. So the dissolution application will contain that all such things of the company, all the assets have been distributed, all the assets have been liquidated, no realizable amounts are pending towards the company, and any amounts that are to be have to be distributed to other stakeholders also have been distributed, and nothing is pending. Once such a clearance is given by the liquidator, once such an application is filed by the liquidator, the NCLT passes an order for dissolution. Once the dissolution order is passed, it is communicated to the authority with which the corporate debtor is registered, the Ministry of Corporate Affairs. So, there are a few landmark judgments. You can have a look at uh, the instance of ABG Shipyard. It's a huge company with a very large debt size. However, they have, due to various complications, the CIRP in this matter was a failure and the company had to be liquidated. The same in case of Lanco Infratech. They have not received any viable resolution plans, and the COC has not approved any resolution plan, so the assets had to be sold under liquidation. And in Amtech Auto, there was a very long delay which caused value deterioration of the assets. So this particular company was undergoing uh, CARP and liquidation prior to COVID. During COVID, they could not sell it, and after, because of the lockdown period, and after the lockdown period was concluded and things started settling down, the auto industry had taken a very huge hit, and because of that, they were not able to sell the assets as quickly as it should have been ideal, and because the assets were lying aside for such a long delayed period, there was a very huge value deterioration of the assets. Liquidation is considered to be the last resort. As I've told you, it is considered as corporate death, but it is a necessary mechanism. Even CIRP is ideal if the corporate debtor has scope to continue as a going concern. But we cannot continue having a sick corporate debtor, sick industry to have. We cannot put all our resources into something like that when it has no scope. So liquidation is also just as necessary, but it has to be taken. That decision for liquidation has to be taken with due diligence. Ensures fair distribution of assets in a structured manner. As we have seen, waterfall mechanism, it provides fair distribution of assets and in a particular order of priority as well. Need for continuous reforms to improve efficiency. So all of what we have seen in theoretical aspect is a tremendous improvement from that of the previous regimes. However, there is a requirement for further reforms and improvements. There are certain industry-specific limitations, even in CIRP also and in liquidation also. So to cater to such industry-specific issues, there are several suggestions provided. So prior to any amendment, the IBBI releases discussion papers wherein it calls for public input. So real estate sector has called for significant improvements in its particular reform and policy. And it is for us to see how it is going to take shape. Thank you all for listening so patiently. and we will conclude our session related to CIRP and liquidation provided under the Insolvency and Bankruptcy Code. Thank you.